I wanted to welcome you to the Cincinnati Bar Association's LGBT Committee CLE for this year. The committee itself is made up, we have 3 officers currently, and we're looking for people to get involved, so I'm excited that how many people are here. So if you're interested, we hope you'll follow up with us and attend the regular meetings, and we are looking for people to continue in leadership. We're one of the only bar associations in America that does have this type of committee, so we are kind of breaking ground there, but we hope presentations like this and we continue to explore these issues in the future. So thank you very much for coming. I wanted to introduce myself. I'm chairing the committee. My name is Tom Hodges. I'm a solo practitioner, and I focus on criminal and civil issues in courts in Ohio and Kentucky. Our vice chair is Lauren Mai. She is a prosecutor with the city of Cincinnati. And Josh Langdon, who you'll hear from as one of our speakers, is our CLE coordinator. As you know, today we're going to be discussing the recent Supreme Court decision, Obergefell v. Hodges. I used to be proud of my name, but today I'm kind of on the wrong side of history. But we have four speakers discussing various topics. I'll introduce them all as they go. Our first speaker is Josh Langdon, and he is an associate with Scott Knox. He has a focus on family law and other issues involving LGBT community. He's a graduate of the College of Charleston and the University of Cincinnati Law School, and he's involved in many volunteer activities, including serving on our committee. So I would like Josh to come up, and he's going to be discussing family law issues regarding the decision.
Thanks, Tom. So basically, I want to kind of start with a historical perspective of kind of how we got here. I did a similar presentation on this topic last week to the Domestic Relations Bar, and I realized that as a gay man, I sometimes forget that a lot of straight people don't really know a lot of gay rights history. So in the grand scheme of things, 1969, the Stonewall riots happened in New York City. And basically, around that time in the country, a lot of raids were happening at gay bars. And so the police would come in and kind of ruffle people's feathers. And finally, people at the Stonewall Inn had enough of it. And so they had this violent protest out in the streets. And that event is pretty much widely known as the event that started the modern gay rights movement. It kind of brought national attention to an issue that has been on the surface for so long. So after that, gay people started to come out of the closet a little bit more, started to really push the envelope, if you will. Some even went to apply for marriage license, and some got them. However, when it came time for the state to recognize them, the state said no. Now, at this time, no statute explicitly prohibited same-sex couples from getting married, although they did have a lot of gender-specific terms, husband, wife, bride, groom, etc. So at that point, some lawsuits happened. One reached the Supreme Court of the United States, and it's this Baker v. Nelson case, which I don't know if you've been following this case in the news, but that was kind of what the attorneys on the other side used as saying, look, this issue has precedent, we've already went over this, even though it was just like a one-line order saying that there wasn't a substantial federal question. So that kind of cut the legal battle at the door, and we didn't have another court case, a big court case, until the early 90s in Hawaii, when the Hawaii Supreme Court kind of shocked the nation and held that Hawaii's statute excluding gay couples was unconstitutional because it discriminates on the basis of sex. However, what the Hawaii Supreme Court did was say, but wait, we'll give you state legislature time to kind of fix this problem, right? So the Hawaii legislature quickly enacted a statute. They also set up this commission on studying sexual orientation and whether or not gay people should be able to get the same rights. And ultimately, it concluded that they should. So in '97, Hawaii enacted this domestic partner registry. So it was pretty much like hey, we don't want you to get married, but we realize that you do have to have some rights, so we'll just give you a few of them. This case worked its way through the courts for about 5 to 6 years, and then Hawaii voters eventually passed a constitutional amendment banning same-sex marriage, which kind of cut that case in the bud. So then that brought huge attention to this issue. In 1996, President Clinton signed the Defense of Marriage Act, pretty much saying that states don't have to recognize out-of-state marriage contracts between same-sex couples, and also the federal government doesn't have to recognize it as well. Okay, so a lot of stuff happens. We're back in 2004 now. Massachusetts becomes the first state to recognize same-sex marriages. That was around the year when there was a big presidential election going on. And so this issue was kind of used as a wedge issue. And so that same year, 11 states passed the Hawaii-like DOMA and added constitutional amendments. Ohio was one of those states. To muddy the waters a little bit more, a lot of states began to have civil unions or domestic partnerships, which was kind of like what Hawaii did, but instead it was to varying degrees. So California, for example, pretty much gave every single right. Parentage rights, divorce rights, but they didn't give the name marriage. Other states did civil unions, which still gave you some of the inheritance rights, etc., again, without the name marriage. What California did then was have a court case that said, okay, it's great that you have domestic partnerships, however, you need to give them the title. So back in 2008, there was this court case that said that your ban on same-sex marriage was unconstitutional. So what did California do? The voters then passed this initiative called Proposition 8, which I'm sure most of you have heard of, pretty much saying, oh wait, California Supreme Court, no, you're wrong. Well, what happened in the meantime? Thousands of people, gay people, got married. So the state then didn't retroactively nullify those marriages, so instead there's 3 classifications of people. People who had domestic partnerships, people who got married during that brief window, and then all the other gay people who just were SOL. So we finally get to U.S. v. Windsor, which is just a tragic case. This widow had a legal marriage contract, but because of the federal DOMA, she had to pay hundreds of thousands of dollars in estate taxes. So the Supreme Court said, okay, that's not right. So if your state recognizes your marriage, then the federal government then has to as well. And then we get to the Obergefell case, which basically was the icing on the cake, saying that every single state has to recognize every single marriage contract. What does that mean? Well, first we got to get rid of the civil unions and domestic partnerships. So it's a separate legal status, and so it's a separate contract. We have a lot of clients who got married in one state or got a domestic partnership in one state, and then got married after that. I have a client right now, just to kind of share with you the kind of facts that we're going to be dealing with. She got a domestic partnership in California, got married in Canada about 3 weeks later. They had a child together after the marriage, and then she moved to Kentucky about a year ago. So she wants to get a divorce. So California is a community property state, meaning you get 50-50, and that's pretty much it. They also have this statute that even if it was separate property, so like if you inherit it, if you transfer the names on the deed, it becomes community property automatically. Well, my client no longer is a California resident. Kentucky, on the other hand, has an equitable distribution statute, and they don't have this exception with transferring title. So if you inherited property, then there's a really good argument that that's separate property. So she doesn't have divorce residency in California, but she does for the domestic partnership. Domestic partnership has all of the the same statutory framework as divorce. So we contacted a California attorney. She's going to get divorced. Well, she's going to dissolve her domestic partnership in California using their framework and then kind of deal with the divorce thing later. But what that does is gets her in the laws of California, right? Well, they have a kid together. So we're in Kentucky now because of the Uniform Child Custody Jurisdiction Act. She has to file the action here. Okay, so is the non-biological person a parent under Kentucky law? The statute says that there's a rebuttable presumption that if you are born of the marriage, then you are a parent under law. So she comes and talks and she says, well, I mean, I'd rather just her, not really be in my life anymore. Is there any way that we could kind of argue that, this statute doesn't apply to her because the marriage wasn't recognized when we had it? And I said, well, we're not really the type of law firm that wants to get rid of a non-biological parent because our law firm deals mostly with lesbian, gay, bisexual, transgender clients, and I can just imagine what that would sound like in a news article, like gay law firm kicks parent out of relationship, right? So no. So I convinced her not to do that, but the question does arise in Ohio whether or not these man, woman, husband, wife, bride, groom, mother, father statutes applies to gay couples and how we can work around them, right? So there are some statutes that say if you are unmarried, right, and you sign an acknowledgement of paternity, you are the legal parent. You're presumed to be the legal parent, but that presumption can be rebutted. And what does the statute say? You need clear and convincing evidence and a DNA test. Well, shocking news, 2 gay people cannot biologically have a child. So where does that leave us with that? We're not sure. My inclination is that the way that the statute's worded now, it really shouldn't apply to gay couples because it's all about paternity and DNA testing. However, there are other statutes. So if you're married, for example, and you have in vitro fertilization, which with gay couples, that's the only way that you can conceive a biological child, unless you have a weird relationship with a family friend, which we've also seen in our cases too. So it's an anonymous donor. I mean, I think that statute clearly applies to gay couples because there's really no difference. One of the parents is not biological. Plus, you're married, so that presumption that you're a parent born after or during the marriage would apply because the contract is recognized now, and so we're going by the state of the law now. But those are just some examples to kind of tell you the messiness that we're dealing with right now. The other big issue, and I'll sum up here because I know we're running low on time, but is whether or not your marriage contract is recognized as of the date that Ohio recognized it, which was just a month ago, whether it was recognized the date that you entered into it out of state, or whether it's some weird date before then because you could never get married yet you lived together for 20 years, had property together, maybe one was the breadwinner, maybe one wasn't. There's a split in the districts right now with straight people because there is a statute that gives the court of domestic relations some flexibility with kind of changing the dates. So there's a split as to whether or not we can go retroactively. The 9th district says, no, that's like reinstating common law marriage. We've already abolished that. Courts can't do that. The 1st, the 8th, and the 12th districts are a lot more flexibility. The 8th district actually went as far back as like 11 years before the marriage. So stay tuned with that. I think that overall, my advice to people practicing in this area of law and other areas of law where, the duration of the marriage or the type of marital contract is a question, is to really discuss it with the other attorney and try to work out what you guys think is the best deal. Until you get a case with really good facts, I really caution people on litigating and creating bad law that we all have to live with. Because at the end of the day, it's all about helping people. These couples have kind of had to go around the legal framework for so long that they've entered into all of these different types of relationships, from real estate, having to go through partition actions, all of that. That at the end of the day, we want to make sure that the result is the right one. So, all right, thank you.
As you can see, there's a lot of issues to explore when it comes to domestic relations. We welcome you to come to our committee and continue to discuss those if that's your area of practice. We also want to talk about employment law, labor law today. While this decision that we're talking about didn't directly set a precedent regarding anything specific in those areas, obviously the development of this law has huge consequences and implications for in the workplace. So our next speaker is Julie Pugh. She's a partner at Graydon, Head and Ritchie in the Labor and Employment Group. She's involved in all aspects of client counseling and litigation in employment law. She's a graduate of Xavier University and then University of Cincinnati College of Law. And she worked as an HR professional prior to attending law school. So she has a lot of insights on the future of employment law and the protections that are out there, and unfortunately the lack of protection in many cases still. So Julie, turn it over to you. Thanks.
Thanks, Tom. It's my pleasure to be here this afternoon. It's great to see all of you. First of all, I'd like to thank Jim for being here. Without you being here, I wouldn't be here, and I don't think we all would be here. So I'd like to be able to say that first and foremost. And while Josh talked a lot about what has changed and what is continuing to change in the area of domestic relations, as Tom said, much of this decision, in fact, almost all but one word of this decision does not really impact what I do. And I deal in the labor and employment world. And much of what I'm dealing with has not changed. So just to give you a little bit of statistics, 29 states do not have state laws banning discrimination on sexual orientation in the workplace. 32 states do not have laws banning discrimination on gender identity in the workplace. Now, while most of what I do is based on federal law, more and more of what I do is talk about what state and local laws impact employment decisions in the workplace. And just so we're switching our mind frame here a little bit, we are talking about employment issues. So it's when you go to work. And some of what we're looking at as same-sex marriage issues post this decision do bleed into the workplace a little bit, but really haven't started making an impact. Now, federal law does have Title VII protected classes. So 1964 really started the protected classes, and those are the immutable characteristics. And hear me, that's the word I'm going to keep focusing on. Immutable characteristics identified in 1964 by Title VII of the Civil Rights Act. There were 5 of them. So we're talking race, sex, color, religion, national origin. So we're going to come back to that sex and gender classification here in just a minute. So what the federal law did is expand, right? Post-1964, you're like, Julie, I know that you can't discriminate against people for disability. Well, that didn't come until later. What about pregnancy? Nope, not until later. So 1967, we expand to protect age over the age of 40. In 1978, expanded to protect pregnancy. In 1990, just 25 years ago, we celebrated the 25th anniversary of the Americans with Disabilities Act yesterday. But again, 25 years ago, right? That's not really long in our history of employment practices. And 1990, USERRA protects veteran status. So where does the same-sex marriage issue fit into the employment laws? Well, way back when, in 1994, the first stab at expanding Title VII took place with INDA, and that's the Employment Non-Discrimination Act. And that act said that we will, from a federal level, protect as an immutable characteristics sex, gender, sexual orientation. But it failed. It failed again in 94, it failed again in 96, it failed again in 97, and then it went quiet for a little bit. Now, I graduated from law school in 2007 after practicing for a few years in human resources. And as I graduate and I'm entering this beautiful world of being able to be an attorney, INDA comes back up, and I'd never heard of it before. I hadn't seen anything about it. And it's going to change for the first time in 13, 15 years, the face of Title VII. It's going to expand those protected classes, but guess what? It failed again. Despite how many times I read it and how much I delved into it, it did not impact what I was doing in my professional career. And it failed again in 09. It failed again in 11. It failed again in 13, and at that point I didn't even read it. It wasn't going to pass anyway, right? So where does that leave us? So this decision, again, comes back to, what is that one word we're going to talk about? Well, in the interim, prior to the June decision that we're all here for today, the EEOC has taken up expanding the definition of protected classes of gender and sex, and that was specifically identified in Title VII in 1964. But now we're going to start interpreting it in a different way. We're going to broaden it. It doesn't just mean because you're a woman. It also means that you could be discriminated against because of your gender, and you're not treated the same as somebody of a different gender. Marriage. Just because you're not married to, a woman's not married to a man, if you're going to treat a woman who's married to a woman differently than a woman who's married to a man, aren't you discriminating against them because of their gender? That's been the EEOC's take on it for several years now. And so that's where, despite the failure of INDA to pass, the federal administrative agencies have started to expand and look at this in a different way, write decisions that allow us to broaden our understanding and look at it in a different way. The case law also started to develop that allowed employment decisions and the protected classes that are considered in employment decisions to broaden. So in PricewaterhouseCoopers, there's a little bit in your materials about that decision. It was a 1989 decision about a woman who's making a partner. Very applicable even in today's world, right? And then OnCal versus Sundowner said that male-on-male sexual harassment is also prohibited under Title VII, just as female-on-female, male-on-female, female-on-male. It goes all ways. We're not going to discriminate on the basis of somebody's gender. So where does that leave us today? And I come back to the decision. There is one portion of the decision. It doesn't talk about whether or not you can be discriminated against in employment. It doesn't talk about whether or not being hired on the basis of your gender is important under this decision. But it does say in a piece of it that it does use the word, and this is the word that jumps out at me, only in more recent years have psychiatrists and others recognized that sexual orientation is both a normal expression of human sexuality and immutable. The decision uses the term immutable. And that's where we come back to, and I don't think that word was put in there by accident. That's where we come back to that Title VII law. And what does that mean? How is that going to be interpreted going forward? And so going forward now, even within the last month, 4 weeks, we have decisions that are going to start really impacting and affecting how employment law is looked at after this decision. And I have two of those here. The first of which was filed on July 14th. It's a lawsuit against Walmart. Cote v. Walmart. Jackie was a plaintiff who has sued Walmart on behalf of similarly situated individuals, so we're talking class action, because as an employee of Walmart, starting in 2008, she was denied the ability to cover her significant other who was suffering from ovarian cancer under Walmart's benefits. And they racked up over $150,000 worth of medical bills. And as of January 1st, 2014, Walmart changed its health insurance benefits policy and allowed domestic partner coverage. But in that interim, there were people that were damaged. And they waited until after this decision to file this lawsuit. The other, which I think is also very, very interesting, is a decision, it's actually a procedural decision filed by the EEOC. What the EEOC did here was a thorough and very interesting analysis of sex and gender as a protected class under Title VII. And if you're not as familiar with the EEOC as I am, it's an Equal Employment Opportunity Commission. It's where it's the federal agency that's tasked with enforcing federal anti-discrimination laws. And so it has now reversed itself, issued a procedural decision, and this complainant, who believes he was discriminated against based on his sex, now has the ability to go back with the EEOC and fight the previous decisions. So it has been reversed. It's a very, very interesting decision. I encourage you all to read it. So there's more to be seen. I think we will see continuing decisions like this. I think case law will continue to shape the way we do businesses. But the end-all, be-all is employment decisions should be based on whether or not the person's qualified, the most qualified person to do the job. And that being that, I will turn it over back to Tom and then to Verna. I welcome all questions after the fact. I think we will have time for that at the end.
We will have some time for questions, so I appreciate your patience. If you could just hold on to them, we'll have a few minutes, and then I think most of the speakers have agreed to stay around for just a little bit for one-on-one conversations after, if you have any questions. So, next speaker is Professor Verna Williams. She's currently a professor of law at the University of Cincinnati College of Law, a founder and co-director of the Center for Race, Gender, and Social Justice. And her research and her classes deal with the integration of race and gender in our legal system. Prior to being a professor, she was Vice President Director of Education for the National Women's Law Center. She's a graduate of Georgetown University and Harvard Law School, and she is here to discuss, I don't really know, but I'll leave it up to you, the Constitution. It's very broad. I'm not going to be too specific, but the constitutional future that kind of comes about with this decision. So thank you for being here.
Oh, great. Thank you. All right. Well, thank you very much for inviting me. Thank you, Josh. Josh invited me to come and speak about the constitutional implications. Tom.
That'll work.
Okay. So thanks to everybody for coming out. Thank you to Jim. I want to thank you and all your co-plaintiffs for having the courage to stand up and take this case all the way to the Supreme Court. I know it was not an easy thing to do, and I just want to say thank you. Okay. All right. Okay, so here's what I'm going to cover in the next 10 to 15 minutes. There are probably tons of constitutional questions that arise from the Obergefell decision, but I'm going to focus on three. The first one being free exercise of religion. The second one being the standard of scrutiny that applies to sexual orientation. And the third one being judicial competence. More specifically, whom does the Constitution authorize to answer this question of whether the question of same-sex marriage? And so I wanted to, in tackling this, I wanted to look at the background, because in preparing for this talk for today, I saw a couple of things relating to free exercise. In the state of Alabama, the Attorney General filed some documents seeking to protect the religious freedom of probate clerks and judges and so forth, because there's no such thing as a constitutional right to same-sex marriage. And it struck me because the court did not find a right to same-sex marriage. Let's be clear. I mean, if that's the way the question is framed, then they lose. So I want to talk about the background so that we're firmly grounded in what it is that the court did. And so what the court did is that it held that the Due Process Clause's guarantee of liberty includes the right to marry. And it identified 4 principles to help explain why that right is broad enough to include same-sex couples. And those 4 principles are up there on the screen. The right to personal choice in marriage, the court said, is inherent in the concept of individual autonomy. Marriage supports a two-person union unlike any other institution. Marriage protects kids and families, and it gains meaning from related rights to procreation, child rearing, and so forth. And then finally, marriage is a keystone of the social order. And the court said that these principles apply to same-sex couples just as they do to different sex couples. I say different sex because sexes are not opposite. It's not up and down. We're just different. Okay. So excluding same-sex couples would be inconsistent with the central meaning of the fundamental right to marry, and it would impose stigma and injury. This is what the majority said. And so with that statement, the court pivoted from substantive due process to the Equal Protection Clause. And it did so because, according to the majority, the interrelation of equal protection and liberty helps to explain the contours of the right to marry. Each leads to a stronger understanding of the other, the court said. And the Equal Protection Clause can help identify, the court said, and correct inequalities in the institution of marriage, vindicating precepts of liberty and equality under the Constitution. And then the court concluded that laws banning same-sex marriage infringe upon the liberty of couples and abridge these principal precepts of equality in violation of the due process and equal protection clauses of the 14th Amendment. Now, the dissenters and others since June 26 have raised this issue of religious freedom. Must clerks and probate judges issue marriage licenses to same-sex couples if doing so is at odds with their religious beliefs? What about religiously affiliated colleges, one of the dissenters asks. Must they provide on-campus housing to same-sex married couples? Does Obergefell mean the end of religious liberty? The post-Obergefell world is not the first time that religious beliefs have bumped up against civil rights, though. Consider Loving versus Virginia. Let me go back. Sorry, I'm too fast with my thumb. Loving, in that case, the state of Virginia's Supreme Court upheld anti-miscegenation laws, in part based on religious beliefs. And it said, Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. Yes, that was in the opinion. But for the United States Supreme Court, the fact that these laws reinforced white supremacy was more than enough for the Supreme Court to strike them down, again, on equal protection and substantive due process grounds. And so it wouldn't be surprising if back in 1967, clerks and judges also sought to deny licenses to married interracial couples based on their religious beliefs. Was the state imposing on their rights by requiring these state officials to issue licenses, irrespective of their beliefs? What would be the harm of allowing such state workers to exercise their beliefs in this way? These are some of the questions that Wake Forest law professor Michael Kent Curtis poses in the article that's in your packet. And he points out that religion has been used to justify discrimination and as an excuse for noncompliance with civil rights protections for blacks and women. He suggests that allowing faith-based exemptions in the area of civil rights is problematic because doing so would undermine the larger constitutional principle of eradicating caste in our society. Moreover, according to Curtis, the Supreme Court's decision in Employment Division versus Smith doesn't require any special accommodations. In that case, the court upheld a state law that prohibited Mr. Smith from getting any unemployment benefits after being fired for using peyote on the job for what he claimed were religious reasons. And the court held that a neutral and otherwise valid state regulation that incidentally interferes with free exercise doesn't violate the Constitution. So, of course, that raises the question, would requiring clerks and probate judges to license same-sex couples meet that standard? Particularly the issue of whether granting such licenses is an incidental burden on free exercise. Well, the next issue may be helpful to analyzing that question. Post-Obergefell, what standard of scrutiny should be afforded classifications based on sexual orientation? And I have to say, this one just jumped out at me reading the opinion again. As I mentioned before, the majority invoked the Equal Protection Clause, but just as it did in the context of the Substantive Due Process Clause, we have nothing about analysis, framework, anything. But in examining the issues at stake, the court suggests that applying intermediate scrutiny to sexual orientation may be on the horizon. For example, early in the court's opinion, the court examines the history and social meaning of marriage, and it tells us that the petitioners don't want to, quote, devalue marriage. Rather, they seek it for themselves because of their respect and need for its privileges and responsibilities. And their immutable natures, Julie, dictates that same-sex marriage is their only real path to this profound commitment. Immutable nature, the court says. 4 pages later, the court discusses the history of discrimination against gays and lesbians to demonstrate how perspectives on gay marriage have evolved. And the court notes that many persons did not deem homosexuals to have dignity in their own distinct identity. Even when a greater awareness of the humanity and integrity of homosexual persons came in the period after World War II, the argument that gays and lesbians had a just claim to dignity was in conflict with both law and widespread social conventions. Gays and lesbians were prohibited from most government employment, barred from military service, excluded from immigration laws, targeted by police, and burdened in their rights to associate. Then the court observed that the medical establishment finally had deemed sexual orientation, quote, a normal expression of human sexuality and immutable. Same language that, in fact, the EEOC quoted the Supreme Court. In these passages, the court employed mechanisms that in the past have supported viewing particular classifications, such as those based on race or sex, with skepticism. Turning to history, to demonstrate how law and society have harmed the group in question, suggesting that in this regard the gays and lesbians are a discrete and insular minority group. Here they were prohibited, quote, from declaring what was in their hearts, because if they did so, discrimination would follow. Stating that the classification is immutable, such that the societal subordination is occurring on the basis of status that is irrelevant to, quote, a person's ability to participate in society. That language comes from the Seventh Circuit. Judge Posner, of all people, recognized, saying that there should be heightened scrutiny, ultimately concluding that such inequitable treatment is subordination that is contrary to the equal protection principle. So, you heard it here first. Finally, turning to the judicial competence and separation of powers, the dissenting judges argue that the court lacks the capacity to even consider this issue. It's a question for state lawmakers. Roberts goes so far as to say the Constitution had nothing to do with the Obergefell decision. And Justice Scalia says the decision is a threat to democracy, in his usual tempered way of writing. I read these dissents as not only an invitation to noncompliance, but also, in part, as an argument about how to read the Constitution, about relying upon the text as the founders understood it, or interpreting the Constitution as a living document. The majority seems to agree with the latter, stating that, quote, the nature of injustice is that we may not always see it in our times, and that the framers, quote, entrusted to future generations a charter protecting the right of all persons to enjoy liberty as we learn its meaning. The dissenters balk at this vision of the Constitution and suggest that the court lacked authority to rule, which no doubt adds fuel to the fire of modern-day practitioners of modern massive resistance. For example, Alabama, not calling names, based on the premise that petitioners sought to change the definition of marriage. The dissenters ask and answer the easy rhetorical question of whether the framers of the 14th Amendment would have understood marriage to be something other than one man and one woman. But applying that reasoning to iconic cases in the constitutional canon suggests otherwise. And here I'm thinking about Brown versus Board of Education, Loving versus Virginia, and Craig versus Boren. Did the framers of the 14th Amendment think they were opening the door to segregated schools, interracial marriage, or the idea that women should be protected from discrimination? The question answers itself, doesn't it? But to be fair to our dissenters, with respect to integration in schools and interracial marriage, the legislative history suggests neither was the goal of lawmakers. For them, the Equal Protection Clause was about political equality and not social equality. They would have been repelled by the idea of interracial marriages, notwithstanding the prevalence of meretricious interracial unions. In fact, my recollection of parts of the legislative history indicates that the framers assured one another that the 14th Amendment would not require integrating schools. And the Brown Court basically punted on that issue, finding that the history was inconclusive on that issue. As for women, recall that in the late 19th century cases, the court said the 14th Amendment was only about protecting newly freed slaves. If corporations could not invoke the 14th Amendment, women didn't have a chance. Women didn't even have the vote until 1920, and the court would uphold every sex-based classification until 1971. And so, should the court have refrained from ruling in those cases, left those issues in the hands of lawmakers? The dissenters' rationale suggests yes. But as Justice Kennedy recognized, these laws carried social meanings that were at odds with our understandings of justice by the time the court heard them. And because each of these cases dealt with discrete and insular groups, the likelihood of getting redress in the legislature was slim to none. Declining to hear such cases would have been making a decision, make no mistake, one that was at odds with the charter our founders gave us. More importantly, as the majority notes, fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. Where the litigants have alleged a denial of a fundamental right by the law, then it's the court's job to address it and to say what the law is. And I'll quote here a good old nugget that you'll remember, Marbury. So, and I'll leave you with this, that as I read the majority's opinion, I saw it as embracing another oldie. I teach constitutional law, McCullough versus Maryland. Let us not forget, it is a constitution we are expounding. So, I'm out of time. I'm happy to take questions. I know it was one-sided. I should have warned you up front. Thank you.
Thank you. Thank you. And last but certainly not least in this is we've got Jim Obergefell. Thank you for being here. I asked him to be here today. Obviously, he's not a lawyer, so that's a good thing. Somebody you might want to be friends with. He's the lead plaintiff in Obergefell versus Hodges. We know why we're here. He's from Sandusky, Ohio. Went to graduate school at Bowling Green University. I think during a weekend away in Cincinnati. Came down to Cincinnati, met a guy named John Arthur, and the rest is history. They were married in Maryland on a tarmac in 2013. Came back, simply asked that their marriage be recognized. It wasn't. Filed a lawsuit in the Southern District of Ohio. Won the lawsuit with Judge Black. Lost in the Sixth Circuit. And then in 2015, won in the Supreme Court. And I just want everybody to know he agreed to speak today prior to the decision. So he was ready to discuss it either way. So I really appreciate your time, your willingness to be here. I didn't ask him to prepare anything specific, but I did, and I think all of you want to hear just about his experience. I told him you're going to have 100 lawyers here, and probably none of us, except for maybe Verna, have actually been in the Supreme Court and seen an argument. Jim has, so I wanted to hear a little bit about that experience. So I will kind of ask you some questions, but come on up. And, all right.
Well, thanks, Tom, for inviting me. I'm thrilled to be here, so fire away.
Well, and that is the first thing I want to ask you is tell us about just your impression of sitting through an hour or 2 hours of argument, whatever you actually were participating in the Supreme Court. You heard, we read Scalia, and you heard him, we read Thomas, you saw him sleeping, so I think a lot of people would just be interested about what that's like to be a part of, especially when your name's on the case.
Yeah, well, for me, I think the biggest surprise was how understandable it was for me, being in that courtroom listening to the oral arguments. I went in thinking it would be so far above my head, and I just wouldn't really understand most of what was said. But it was all in very simple English, and I was really happy about that because I could follow it. I could really understand what was being said. Now, I think another thing that surprised me, and this was before oral arguments even got started, was just how theatrical that courtroom is. I mean, it's smaller than I expected, but it has all of these dark red drapes with gold fringe. Put me in mind of a French, I'll let you fill in the next word. It just wasn't, it surprised me. It wasn't what I expected to see. And just the theatrical nature of it. So, we're all sitting there, and buzzer goes off, we all stand, and these gaudy red drapes are pulled back, and there are the justices. I felt like I was in the Muppet Theater, honestly. And I think Statler and Waldorf were on the bench. So that surprised me. It wasn't as overwhelmingly formal as I expected it to be. And there were quite a few times during oral arguments I had to sit up in my seat and strain to see Justice Thomas, because I'd look at the bench and I'd see Justice, Justice, blank space, Justice, Justice. And he was leaning so far back in his chair that you couldn't see him. So found myself thinking quite a few times, are you really paying attention? Are you participating in this? But I've come to understand that's just how he is. I was very surprised to actually hear him speak on the day during decision days. He actually has a voice. So sitting in that courtroom, the other things that just really made an impact on me, I expected that plaintiffs in a Supreme Court case are guaranteed seats. They're not. Attorneys are guaranteed seats, guests of the justices are guaranteed seats, journalists are guaranteed seats, but plaintiffs aren't. So it wasn't actually until the week before oral arguments that we all found out that we actually were going to get seats. But we were only able to get seats for half of the arguments. We had to choose, do you want to see the arguments for the right to marry or the arguments for the right to recognition? I was fortunate enough to actually work with the group, and they got me in for the whole thing. So I'm the only plaintiff who was there for the entire 2.5 hours. But that surprised me. I thought none of you would be here if it weren't for a plaintiff. So that was a surprise, but being in that courtroom and sitting somewhere where I was somewhat anonymous, it was really surprising. I was sitting on the side, and Aunt Paulette, who married us, was next to me. And there were some people sitting in front of us, and one of the gentlemen right in front of us was a law student from Chicago, but originally from Youngstown. And when he realized who I was, he just burst into tears. And every time he turned around and looked at me throughout that day, his eyes were just filled with tears. And that was really touching. And that's been my experience really from the start. People relate. They really respond to our case. But then the other really surprising experience I had with the people sitting around me, the gentleman just to my left, also an attorney, he had had at least 1 or 2 cases in the Supreme Court, and he kind of talked to me about how things work. After oral arguments, that Friday they meet, they make a decision, they decide who's writing the decisions. And we're talking, and he tells me that, Jim, I have to tell you, your story really touched someone this morning. My brother, my twin brother, who's a Roman Catholic priest, knew I was coming to oral arguments today, and he called me to say, Rob, I just watched this video about the named plaintiff, and I have to tell you, it really touched me deeply. A little bit later, Rob says, well, there were 2 people your story touched today. My brother, the Roman Catholic priest, and me, and I'm an evangelical Republican. And he shook my hand and thanked me. So that was just one of those other really unexpected experiences for me in that courtroom, was to have someone like that talk to me and say that to me and shake my hand and thank me. So that day, kind of a blur. I tried not to pay too much attention or read anything into what was being said because I know I'm not an attorney. I don't know the justices well enough to understand if this justice asked this question, it's because he or she is on our side, or it's because he or she is trying to expose a weakness. So I really just went through the day and let it happen. I tried not to read much into it. And that was my goal. After I left that courtroom, I thought, I'm not going to think about this. I'm not going to form an opinion other than my own very personal opinion that absolutely we were on the right side. We deserved to win. But as those 2 months went by, and every single article I read from an attorney, from a court watcher, every single person said, they're going to win. It's kind of hard not to kind of start believing that. So when it came time for decision, I had the opportunity to be in DC, and I sat through 5 days worth of decisions. And I went in thinking that our decision's going to come out on Monday, June 29th. And I thought that until Monday, June 22nd. And decisions were read that day. We're out front of the courthouse, and someone comes running out to say, well, they just added Thursday. A couple minutes later, well, they just added Friday. And that's when I think all of us started to think, Friday, June 26th. That's kind of a good date for gay rights cases in the Supreme Court. So started to think it is going to be on Friday. So just to kind of talk a little bit about how Thursday and Friday differed being in that courtroom. Thursday was the day the ACA decision and the fair housing decision came down. And from the moment I got to the courthouse that morning around 6 or 6:30, standing in line, because I was in the public line, still had to get a ticket, and then waiting inside the courthouse before going up to the courtroom, it was tense. And the courtroom that day was very tense. And it really became clear the next morning when I showed up for Friday, decision day, and I got there, and the whole atmosphere was lighter. It was looser, it was happier. Even just standing in front of the courthouse, we got into the courtroom, there was just a different energy. It's the only way I can describe it. And even when it came time to be seated in the courtroom, they seated people in the courtroom completely differently than any other time I'd been in the courtroom. So there were all these things that were kind of saying, today might be the day. I think it might be, and then it just felt different. And for me, sitting there waiting, the Chief Justice says, Justice Kennedy will read the first decision, and Justice Kennedy reads our case number, and I just freaked. I don't know why. I knew it was possible it was coming, but it just was a really big surprise, and I grabbed the hands of the friends who were on either side of me and started to listen, and I'm thinking, okay, this is good. Well, I don't know. And then 3 or 4 sentences in, became clear, I started crying. And looking around that courtroom, there were so many people crying, and just, you could hear people sobbing, and it was incredible just to hear Justice Kennedy say in that courtroom, your relationship, John and Jim, everyone like you, all the other plaintiffs, your relationships are just as valid, just as worthy of respect. I felt more like an equal American that day. So he read his decision, and then I got to listen to the Chief Justice read his. And that was okay, I won. And then we had to sit through 2 more rulings. And I was just sitting there, let me out. So it was quite an incredible experience. And the one thing I was really waiting for that day, when the decision came and assuming we won, I was waiting to walk down those front steps. So we were gathered, and there were 4 other plaintiffs who were there, and Al Gerhardstein, my attorney, and people from the ACLU and Lambda, and we're all gathering to go down the steps, and suddenly all of the police officers went running out of the building. And we're looking around, well, we don't know what's going on. So we start to walk towards those doors to go down the front steps, and another police officer stops us and says, you can't go that way. You have to exit the side. We still don't know what's going on. So we exit the side, we come down to the sidewalk, and then we go up onto the plaza. And it was such an incredibly moving experience to walk through this mass of people that parted like the Red Sea. And just the cheers, the tears, it was an incredible experience. And it turns out the reason the police officers had to run out, the crowd surged forward, much beyond where they were supposed to be. So just from a safety point of view, we weren't able to go down those front steps. So yeah, and I won. Just
We only have a few minutes left. I intended to open it up for questions for everybody, but I'm not sure we have time for any. If we have a few questions for Jim, I'll open it up for that. Go ahead.
I would like to know where you can find that moving video that you referenced that moved the lawyer in the crease.
that was the video that the Cincinnati Enquirer did. We got married on a Thursday, and there was a story about us in the Enquirer that very weekend. So I think it's out on YouTube somewhere. I know it's owned by the Enquirer, so they probably have it behind paywalls somewhere on their website. But it's out there somewhere. You probably should be able to find it pretty easily. Yes?
I'm curious how this all that you feel after being really probably the greatest plaintiff since Brown.
It's still sinking in. It doesn't feel real to me yet, and I'm not sure when it will, but I will tell you it feels really good. Everywhere I've traveled this year, just to go places and to have, I'll give you a couple examples. I was in Philadelphia over the 4th of July weekend, and after the event ended, I was walking away, and there was a gentleman on the sidewalk not far from me, and all he did was hold up his left hand, pointed at his wedding ring, and said, "Thank you." That same weekend, I was walking down the street. I was just out wandering the city, and a married couple, husband and wife, and their 2 kids in strollers, they stopped me and thanked me and said, "Can we get a picture of you with our children?" So I crouched down behind the strollers. They took a picture of me with the 2 children. A little bit later that day, they tweeted it with a thank you, just to say, "Jim, thank you for making the world a better place for our kids." And that happens everywhere I go. I mean, people tell me stories about how it impacts them personally, how it impacts someone they care about. People cry, they hug me, and I knew I was doing the right thing. And John and I made that decision for us. It was a very personal decision, and over time, it's certainly become so much bigger than just the 2 of us. And it's those personal interactions that I continue to have every day that it was worth it to start with, but those just make it even more important to me. So it's been incredible.
Yeah, let me say, you're already a hero to me because I have a very close friend whose husband is ALS. I've cared for him for 10 years, and I know what you did as a husband is more than he wants to listen to whatever you do, no matter how much we love them, the selflessness.
Thank you. Thank you. I made commitments to John. I promised to love and protect him, and I couldn't think of anything else to do. I mean, there were no other options. I had to take care of him, and I had to fight for him and for our marriage. So, but thank you. I appreciate that.
Yeah, you're a hero.
Thank you.
Every way.
Thank you. Yes?
Now that you've been through all of this, what's next?
I'm still trying to figure that out. I will say I've discovered about myself, and you might have heard this, I've said it a lot. I'm an accidental activist. John and I never did anything. Our brand of activism was, where do we sign the check? And I've discovered over the past 2 years that it's really important for me to be involved in something that's bigger than I am, that's more important than I am. So I'm absolutely going to be involved in the fight for LGBT equality and just civil rights in general going forward. Still figuring out what that is. I'm also just hard at work writing a book. You might have seen that in the news. Sold a book, also sold the movie rights. So my life has taken some really interesting turns that I never expected. So that's kind of what I'm thinking, but how it actually all falls out and what it looks like, still not sure. Thank you.
Our time is up. I appreciate everyone coming. I appreciate you coming, Jim.
Jim.
Thanks so much for doing this. And if you haven't already done so, I would ask everybody to join the LGBT committee. I think you can do it at the Cincinnati Bar website. We'll continue this conversation and figure out how we can make sure equality is there for everyone. It is a CLE today, so I think there's probably some directions. But thank you all for coming. We appreciate it. Like I said, the speakers have agreed to stay for a few minutes if you have any questions afterwards. Thanks so much.
Thanks for having me.